All right, kids, are you buckled in? This is going to be a long ride. So go ahead and pause this, grab yourself coffee, maybe take a dump, whatever you need to do. You can see all the tabs I have, lots and lots of tabs. We are on the train to Crazy Town. And it's nonstop. All right, let's go. First, we have the arraignment sheet. I was wrong. I admit it. I was wrong. Mr. Freeman did request a court-appointed lawyer. This is back in 2015. Third day of June 2015. This is his original arraignment sheet. He said, yes, I do want an appointed lawyer. He says he made no monthly income. He is indigent. He has no assets, no house, no cars, no cash, no stocks, no bonds, no other. And he signed that. And there you go. He was appointed Attorney Woodruff on June 4th, 2015 by Judge Amber Givens Davis. That name will probably ring a bell. Skip ahead almost 3 years, and we have, this is the true bill that was returned by the grand jury of Dallas County, State of Texas, duly organized at the January term AD 2018 of the Criminal District Court number 2 for said county, upon its oath, do present in and to said court at said term that James Freeman, hereinafter called defendant, on or about the 17th day of May 2015 in the County of Dallas, State of Texas. You'll notice they said who did it, and they said where he did it. In the County of Dallas, State of Texas. So he said where. He said where he did it. Without obtaining the consent of, and I have redacted the name of this person. There is only one person named in this. I did redact. Why did I redact that? I'd have to unredact it, and I don't want to do that. Okay, so without obtaining the consent of this person, intentionally and knowingly use the name and persona of that same person to post one or more messages on or through an internet website, namely it's Facebook. I don't know why I redacted Facebook. With the intent to harm, intimidate, or threaten that person. And the internet website was not an electronic mail program or message board program. That is the against the peace and dignity of the state. That's the harm, by the way. It's against the peace and dignity of the state. He's going to try to make some stupid arguments, misunderstanding words. But even if he understood the words correctly, even if he was correct in his argument, we'll get to it. But just remember, they have stated where he did it. They have stated when he did it. And they have stated what crime he committed and who was harmed by it. Who was harmed by it? Well, there are two people. There's a person that he intended to harm, intimidate, or threaten. And there's also the peace and dignity of the state. I hope I did redact everything correctly. I redacted the SID number and the AIS number. I don't know what they were. I don't know what they stand for, but there you go. And again, this is the 282nd right there. And then boom, they send notice to Attorney Woodruff. And Jerry docks bail bonds. That is his bail bondsman. I don't have their bail bonds up here because it was a useless document. And I have way too many. See a little arrow going over? I got way too many documents up here anyway. So please accept the message's notification that the case has been scheduled for May 23rd. I don't know why. I don't know what is going on with his attorney. His attorney really should have talked to the judge, have submitted a motion to withdraw or something, but I don't know. So I don't know what's going on. I don't have any access to that. I don't see any evidence of a motion to withdraw anywhere. It's from Judge Amber Givens Davis's court. Just some general information. And then this is a relatively generic motion. This is a request for discovery and Brady request. Technically, you don't have to make a Brady request. Brady request just is a request for all potentially exculpable information. Everything that tends to say that you're not guilty of the crime. All the evidence that may indicate you did not commit the crime. It's just a request for that. And he calls himself an alleged defendant. No, he is the defendant. There's no allegation about that. He is the defendant. He is an alleged online harasser, but he's not an alleged defendant. He is an actual defendant who hereby requests counsel for the alleged plaintiff. It's not the alleged plaintiff. It is the prosecution. He even put plaintiff in here. It's prosecution. State of Texas is the prosecutor. So this looks like a civil, because the way he put that in there, he has his address up here. Yes, I did redact that. Only to avoid further. Okay, so yeah, all my interactions with government employees are under threat, duress, and coercion, only to avoid further aggression against me and not a waiver of jurisdiction. Oh my God, that's soft-sit nonsense right there. Just saying that you're interacting with them under threat, duress, and coercion doesn't mean anything. It literally means nothing. Yeah, obviously they know that you're doing this because you've been indicted. They know that. They're fully aware of this. They're the ones actually who indicted you, so they know what happens to you if you fail to comply with any of this stuff. Yeah, they know that you're facing jail time. What, 2 to 10 years, I think, for a felony 3 in Texas. So yeah, this is serious stuff. I mean, you might get a new prison boyfriend. This is also a Brady request. I don't think you have to make Brady requests anymore. I think, if I remember correctly, the Supreme Court said that the prosecution has to. They have a constitutional mandate to supply you with that information. But I guess it doesn't hurt to ask. So I'm not going to fault him for asking. So he asks for the names of every witness with personal knowledge that the prosecution relies on to prove the alleged defendant's presence within the state of Texas. The alleged defendant's presence within the city of Rowlett. I don't know technically that the indictment said that he was within the city of Rowlett. It just said, yeah, he was in the county of Dallas, state of Texas. We were here, the miscellaneous one. Alleged defendant's presence within the city of Rowlett. Alleged defendant is subject to the laws of the plaintiff state of Texas. Plaintiff state, my God. The Constitution and laws of the plaintiff state apply to. They want the names of every witness with personal knowledge the prosecution will rely on to prove the Constitution and laws of the plaintiff state apply to the alleged defendant just because alleged defendant is physically in Texas. Oh my God. Oh my God. So the witnesses with guns in the courtroom and outside the courtroom with guns and badges, those guys all say, and they mean it, that when you're in Texas, you're subject to the laws of Texas. And you can argue with them, but there's a lot of them. And they got a lot of guns and a lot of bullets and a lot of pepper spray and a lot of tasers and a lot of handcuffs. And by God and by golly, they could probably get bigger, badder stuff too if they needed it. And if they really wanted to, I'm sure they can get the governor of the state of Texas to call out the Texas National Guard to prove it to you. But I'm pretty sure that somewhere along the way, one of them is going to prove to you sufficiently that you believe you are subject to the laws of Texas when you're in Texas. Oh my God. A valid cause of action, injury and damage corpus delicti has been presented to the court. Yeah, okay. Yes, they will have to prove their case, but they might not be relying on a person to do it. So it was Facebook. I blocked out Facebook. I don't know why. I got a little excited with the censoring tool. But yeah, so it is Facebook. So they might have just requested, the logs from Facebook servers and things like that show, IP addresses and all that other fun stuff. And they might also request logs from internet providers who connected him and, show who was on the bill and all that other fun stuff. I mean, I'm assuming they're not going to rely only on witnesses with personal knowledge, because, if it's computer tracking it, that's not. See, anyway. The name of any witnesses who are experts in the interpretation and application of Texas law, including Texas criminal laws, the prosecution relies on. The prosecution relies on the judge. I think you have her name, or had her name. You got a different judge now. And, so judges typically take judicial notice of the laws of the state. You don't have to prove them in court. They literally just look them up. They're like, yeah, this is the law right here. Boom. They take judicial notice of any case law from the state. Like, yeah, that's case law. They may distinguish it or overturn it or something like that. But they take judicial notice. They don't need anybody to come in. They don't need experts to come in and say, this is the law of Texas. And you're not going to impeach the judge, bro. Sorry. He's so stupid. Any and all evidence known to the complaining agent proving alleged defendant was present within the plaintiff's state of Texas. So he's asking for any evidence known to the prosecution proving defendant was present in Texas. Any evidence. And then he says facts, not argument, allegation, and opinion. An allegation is evidence. If I say, I saw you in Texas, that's an allegation. But that's also evidence. Because I say I've seen you there. Now, whether I have or haven't is, whatever. But it is evidence. Known to the complaining. See, you always know when you're dealing with the sovereign citizen, because they like to throw word salad out there. Because that is just word salad. I mean, can I get some balsamic vinegar on that? Proving defendant was in the city of Rowlett. I don't know if it turns on the defendant being in Rowlett, because again, the indictment just said that you were in the county of Dallas. I didn't see anything in the indictment about being in Rowlett. So, yeah, I'm not sure where he's going with on that. Any evidence, again, blah, that defendant is subject to the Constitution and laws of the state. Yeah, you're retarded. You're retarded. Any evidence of valid cause of action, they've already given that to you. That is the indictment. Names of any other witnesses to support an allegation. So yeah, he's already asked for them. The police officers, okay, this is good. He's asking for the police officers' reports and notes regarding the stop and arrest, including any audio, video recordings of the stop, such as a dash cam video. I don't know what that is going to go to prove the online harassment. He's also asking for the original complaint written by the police officer submitted to the court. Okay. Evidence he has to prove the witness relied on to have personal first-hand knowledge of the matters they testified to. So all they have to do is say, yeah, I saw, like, again, they call me up to the stand. They say, did you see defendant enter the grocery store? Yes, I did. Did the defendant have anything in his hands? Yes, he did. He had a pistol in his hands. How do you know it was a pistol? Well, it looked like a pistol, and I know what pistols look like. Okay. Do you know what kind of pistol it was? I'm not an expert. I just know it was a pistol, or it was pistol shaped. Maybe it was a toy, but it looked like a pistol. Something, you know. So I could testify as to what I saw. Now, could you impeach me and say you don't actually know it was a pistol? Yeah, you could. But if I did know exactly what that pistol was, you know, oh yeah, it's a Glock, you know, this model number, whatever. There's some guys out there who could do that. So like, if I did that, then sure, great. I have firearms, but I'm not really a firearms junkie. Anyway, enough about me. The names of any witnesses relied on by the prosecution that have been dishonest during investigations and trials, and anything relevant to guilt or punishment and is exculpatory or favorable to the defense. So he's asking about the Brady stuff. Any material, including but not limited to videos, audio recordings, and written reports that may be used to impeach prosecution witnesses. I don't know. I don't know if he's going to get all that stuff. I don't know. I don't know if he's going to get all that stuff. That's questionable. I don't practice in Texas. I don't know if he's going to get all that stuff. So just take that. And he hand delivered it. So cute. All right. Now we're almost to the good stuff. We're almost to the good stuff. This bad boy right here. This is where the fun begins. I'm going to short circuit this by saying that he did copy this out of Mark Stevens' Adventures in Legal Land by Mark Stevens. I didn't actually look to see who this... Mark Stevens. We're going to go to Quatloose. Okay, yeah. So Mark Stevens is a Mark Stevens is a sovereign citizen. This is Quatloose. If you're ever wondering if someone is a sovereign citizen, if they have an entry on Quatloose, you can be sure that they are sovereign citizens. There's a lot of lawyers and judges and other people who are just interested in sovereign citizen shenanigans. That's what Quatloose is. So there you go. Exactly as I suspected. Now, there are lots of miscited cases in here. So if you are thinking that you're going to use anything like that, I would not recommend it. When real lawyers do legal research, they go to a law library. They start like, okay, so I just recently, I'm working on a case, and the question came up whether or not in a civil case in California, can a victim of domestic violence who is suing her abuser in a civil case, can she refuse deposition under Marcy's Law, which is Article 1, Section 28 of the California Constitution? B5 says that they can refuse deposition. Victims can refuse deposition. And depositions are only done in, or at least in California, depositions are only done in civil cases. Criminal cases, there are no depositions because, you know, you have the right to cross-examine and et cetera, et cetera. So the first thing I did when I went to, you actually go to a library. I mean, I guess if you're rich, and I'm not, you can pay for subscription to LexisNexis or Westlaw, or if you're working for a rich law firm that can afford to have subscriptions to it, then great. If not, you go to the law library, and if you're lucky, there's a computer available and you could use LexisNexis or Westlaw. And if you're not, you're looking up books. But you start by, like I started by pulling the Deering's and Westlaw books on the California Constitution, looking up Article 1, Section 28, seeing all the citations, all the cases that Deering and Westlaw thought were relevant. They do break them down into like little relevancy groups. And then you write down all those little citations and you go to the various books and you look them up. And the great thing about it is all those cases are relevant to California law. The next step that I did is I went to the California, the CCP, the California California Code of Civil Procedure. There we go. The CCP. And I went to the deposition sections and I started looking to see if there's anything from the deposition side referencing back to Marcy's Law. And then all the cases that you found that you thought were relevant, you would look through to see if they were still good law, et cetera, ad infinitum. It's called shepherdizing. You go find the shepherdize, or the little, the book that is the current softback, and you look through that, et cetera, to see where the cases were cited, how they were cited, if it was positive or negative or otherwise, et cetera, et cetera. You can short circuit all that just by going on LexisNexis or Westlaw. But anyway, you don't look up something like this. One other thing that you always do is after you look up the cases, you actually read them. You read the whole case because that is important. So you don't look at something like this where they start giving you like one sentence out of a case. You just don't do that. First of all, you don't know how that case was treated subsequently, or how that section was treated subsequently. You don't know whether the state laws changed that case was ruling on. There's just so much you just don't know, that you don't just go to a web page like this and see a 1 sentence or 2 sentence description from a case, trust it to be accurate, and some of them aren't, and roll with it from there. So now that I have that out of the way, we're going to start with this. This is a motion to strike / dismiss complaint. That's really weird that he would motion to strike the complaint, but okay. And request for full finding of fact and conclusions of law. Well, that's what a trial is. A trial is where they determine the facts. Now, in civil cases, if there aren't any contested facts, like if the plaintiff submits a complaint or a claim, and the defendant submits an answer, and they agree on enough facts that the judge can make a ruling based on the uncontested facts, he can make a ruling as a matter of law because there are enough uncontested facts that he can make a ruling. If there are contested facts, then he can't make a ruling. He can't give summary judgment. He can't, dismiss the claim or whatever. It's got to go in front of the jury, or if the judge is going to be the trier of fact, it has to go in front of the judge. And then in a civil case, the plaintiff would present all the elements of their case. They would lay out the facts. A prosecutor would also lay out the facts in his case. And then at the end of the plaintiff or the prosecutor's case, if the plaintiff hasn't alleged facts that are sufficient to establish his claim, or if the prosecutor hasn't proven the elements of the crime, like if there's an element of the crime that is left unproven, then the defense can move for a summary judgment. And then if the judge agrees with them, then then it's done. If not, if the judge doesn't agree with them, then the defense can present their evidence. And then typically the defense moves for summary judgment again. And then, I mean, because you just do it. And then the judge will either grant it or deny it. Typically the judge will, at that point, just deny it, because you might as well let the jury decide on it at that point. I mean, they've sat there the whole time anyway. So then then the jury comes back and the jury will say what the facts are. The jury determines the facts, the judge determines the law. So asking for a full finding of fact in a motion to dismiss is really weird. And since there is an indictment, a grand jury has already found that there's probable cause for the crime. All right. So again, he styles the state of Texas as the plaintiff, which is really weird. Now comes James Springer, alleged defendant. Again, he is a defendant by special appearance. Special appearance is what you do to challenge jurisdiction in civil trials, in civil cases. If you're a resident of Nevada and somebody sues you in federal court in California and you think that they lack jurisdiction because the amount in controversy isn't sufficient or there's no federal question, you can show up by special appearance to challenge just the jurisdiction. And by showing up by special jurisdiction, you're not in the state. The only reason you're in the state is to challenge jurisdiction. They can't tag you in state. It's just a protection so that you could show up, challenge jurisdiction, and GTFO without being tagged in state. Because if they serve you in state, then they have jurisdiction. But again, that's a civil matter. Participating under threat, duress, and coercion, again, that's just sovereign citizen nonsense. It's meaningless. Not submitting to the court's jurisdiction. I don't think you have a choice. Who hereby moves this court to strike, dismiss the complaint filed by, and then in quotes, state of Texas. That's really weird. For failure to present a cause of action or crime. Again, that was the indictment. That was the cause of action. That was the crime. And it wouldn't be a cause of action. It would be a crime. Failure to present the court a case deprives the court of jurisdiction. The court has the arraignment from the magistrate, which I believe this did, yeah, this is a finding of probable cause, I believe. There was probable cause, or else. Yeah, so there was a finding of probable cause in the arraignment, I'm guessing, or else they wouldn't have referred him up. And then there's also an indictment, so there's plenty there. All right, so he says there's no case, crime, or cause of action. That's hogwash. We've already looked at it. It is an actual Texas penal code. A grand jury thought that there was probable cause. The foundation of this court's jurisdiction is the purpose of the American government itself. And this is in the Declaration of Independence of 1776. The Declaration of Independence, while it is a beautiful piece of writing, is not law. Only retards think the Declaration of Independence is law. It is not law. It is the declaration. It's saying we are declaring war on Great Britain for our independence. It is not law. There's zero legal effect of that. And so he says this is applicable to Texas governments through the Texas annexation of 1845. Okay. This is also shown in several other state constitutions regarding the establishment of American governments. Governments are established to protect and maintain individual rights. Okay, those are other states. Those are meaningless. But that is interesting. Let's look up the Arizona Constitution. Oops. A. And then we're looking for are established to protect. Indeed, it says it in there. Okay. Now, it is established to protect and maintain individual rights, but that is not the sole purpose of any government. Governments are established to do many things. Governments are established to make roads, provide education for children, whether you agree with that or disagree with that. There are reasonable arguments to be made on both sides. To fight fires, to fight crime, to protect the sovereignty of the nation itself. There's lots of reasons there's lots of purposes for governments, not solely to protect and maintain individual rights. But in protecting and maintaining individual rights, they also are there to protect your rights from other people who are going to attempt to trample them, like people who are going to kill you or commit online harassment by taking your name and using your name to threaten, intimidate, or otherwise harass other people. Standing is required because courts only adjudicate justiciable controversies. Justiciable, I think, is the way it's actually pronounced. Courts only adjudicate justiciable controversies. U.S. v. Interstate Commerce Commission. Well, that looks interesting. Courts only adjudicate justiciable controversies. Well, the U.S. v. Interstate Commerce Commission. The Interstate Commerce Commission, as you may well guess, is a sub-agency of the United States. So what we have here is the United States versus the United States. The United States, as a shipper, having undertaken to provide wharfage and handling services at certain piers, requested railroads make an allowance for expenses thus incurred, since the ship side rates allegedly included charges for wharfage and handling services. The railroads refused to make an allowance and to perform the services. The United States thereupon filed with the Interstate Commerce Commission a complaint, alleging that in refusing to make an allowance for wharfage and handling services, the railroads had exacted payment of rates which were unreasonable, unjustly discriminatory, and otherwise in violation of the Interstate Commerce Act, asking that the Commission, which is an agency of the United States, find the charges unlawful and award the government reparations. The Commission denied reparations and ordered the complaint dismissed. The United States then sued in district court to set aside the Commission order. The Interstate Commerce Commission and the United States itself were made defendants. You could see the problem here. This would be like you suing yourself for damages. There is much argument with citation of many cases to establish the long recognized general principle that no person may sue himself. Properly understood, the general principle is sound, for courts only adjudicate justiciable controversies. They do not engage in the academic pastime of rendering judgments in favor of persons against themselves. Thus, a suit filed by John Smith against John Smith might present no case or controversy which courts could determine. But one person named John Smith might have a justiciable controversy with another John Smith. This illustrates that courts must look beyond names that symbolize the parties, blah, blah, blah. So what they're saying here, what they're looking at is the United States being on both sides. One portion of the United States suing another portion of the United States, one portion of the United States government suing another portion of the United States government. So that's retarded. It doesn't say what he thinks it says. He never read the case. He doesn't know what he's talking about. So standing is required because courts only adjudicate justiciable controversies. Looking in this case, which is a civil case, it is not a criminal case. Federal courts always have to look at standing, just in general. And one of the things is that, it has to be, what is it? Is it RAMPS? I forget the acronym or the whatever that they use. Mootness is one of the things. Standing. Oh, it's been a long time since I've looked at that. But anyway, yeah. So they need to have parties on either side of the controversy. Which is why to have a case or cause of action, a plaintiff must plead the violation. Again, it's not a plaintiff. It's not a plaintiff. It is a prosecution. Plaintiff must plead the violation of a legal right. And now he's citing Tyler v. Judges of the Court of Registration. Tyler v. Judges of Court of Registration. This is a 1900s case. And it is a civil case. I don't remember. I read it previously, but I don't really care enough. All right, so he says the duty of this court, as of every judicial tribunal, is limited to determining the rights of persons or property. All right. When determining such rights, because it's necessary to give an opinion upon a question of law, the opinion may wait, blah, 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 but the court is not empowered to decide moot questions. Yeah, so mootness. This is mootness. So moot questions, there's no case or controversy if the question is moot. So like, if you sue someone over the ownership of a dog, like let's say for example that you're going through a dissolution of marriage and you're fighting over with your ex over custody of the dog, and then the dog dies. The court is gonna drop that. The dog's dead. There is no longer any actionable claim here. If you're charged with a crime and you die, the case will probably be dropped. I mean, somebody might sue your estate over, to try to recover some damages or something like that. But the criminal case is done. It's moot. You're dead. They can't incarcerate a court. I guess they can't, but you know what I mean. They're not going to put your corpse in jail. They're going to put it in the ground. You're done. It's over. So this case, first of all, is really old. So you do have to worry about that. If you're citing a case from 1900, things have changed since 1900. So be very careful about really old cases. If you can't find a newer case that's dealing with whatever you're trying to argue, then you might want to rethink what you're trying to argue. The basic elements of a case or cause of action, again, we're dealing with a criminal action, are the violation of a legal right and loss or harm. That's not, I mean, maybe, but no. You're violating the laws of Texas, and the harm you're causing is to the peace and, the peace and dignity of the state of Texas. All right, somebody's crying outside. That's sad. The alleged plaintiff, a legal fiction at best. No, the state of Texas is an actual entity. It's not a legal fiction. Ostensibly acting through state of Texas, has not pled any violation of a legal right or harm. And yes, they have. That's the indictment. Texas courts, like other American courts, are limited to only cases. See the Texas Constitution, Article 5, Section 8. This is Article 5, Section 8. And he says it's limited to only cases. Let's see what it's limited to. And this is just the district courts. There's also the county courts, which get misdemeanor cases and other things. But anyway, district court jurisdiction consists of exclusive appellate and original jurisdiction of all actions, proceedings, and remedies, except in cases where exclusive appellate or original jurisdiction may be conferred by this Constitution or other law on some other court, tribunal, or administrative body. District court shall have the power to issue writs necessary to enforce their jurisdiction. So this is wrong. Texas courts, or at least Texas district courts, have original and exclusive appellate and original jurisdiction of all actions, proceedings, and remedies. They can't make it any clearer. It's not just cases. It is actions, proceedings, and remedies. Under Texas law, there is no cause of action or case. Yeah, there is. It was the what was it? Texas Penal Code 33.07. Well, look at that. It's like I've been here before. 33.02. 21. Wait, did I miss it already? Breach of it's down near to the bottom, I think. Online impersonation, right there. It is a crime. A person commits an offense if the person, without obtaining the other person's consent, etc., 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 uses the name of another person to post or send one or more messages on or through commercial social networking site. It's this one. That's what he is accused of doing. So yeah, Texas law, there is a cause of action or case. So, all right. So then he quotes, it is too elementary that injury must be pled and proved before a cause of action arises to require the citation of authorities. This is Whitesboro National Bank v. Wells. Let's see. Whitesboro, there we go. Whitesboro National Bank v. Wells. The record will no more justify the presumption that there are unsatisfied creditors than it will the RFC supplied funds sufficient to satisfy all claims in full. It is too elementary that injury must be pled and proved before a cause of action arises to require the citation of authorities. However, in substantiation of the proposition of the rights of third parties must intervene and debts and creditors must be shown, we cite these people. In our view of the case, there is no estoppel established, and the sole remaining question is whether or not the note is accommodation paper. This is, again, a civil case. It is a Texas Court of Civil Appeals, Texas case, where a guy gave a lady a note. No, she gave him a note. He was a bank, because this is an old case, 1944. He gave her a note the next day, and neither one of them knew if the other had money that could actually pay for the note, etc. But yeah, you don't get, until somebody tries to collect on the note, there is no action. Anyway, it is a poor citation. You don't want to cite civil cases in defense of a criminal case. This includes proceedings like these allegedly criminal in nature. And then this citation is Salazar v. State. All right. So he's talking about the corpus delicti rule. Over time, the corpus delicti rule was expanded to cover crimes other than murder. Now keep that in mind. This case is talking about the corpus delicti rule. Wigmore explains the American concept of the corpus delicti rule thus. Wigmore explains the American concept of the corpus delicti rule thus. Every crime reveals three component parts. First, the occurrence of a specific kind of injury or loss, as in homicide, a person deceased, in arson, a house burnt, and larceny, property missing. So for every crime, there has to be there has to be a dead person for there to be a homicide. Does that make sense? So there has to be a specific kind of injury or loss. Now that doesn't say it has to be an injury or loss, because this is a very general statement. Secondly, someone's criminality in contrast as to the source of the loss, as in contrast to accident. So there has to be an arsonist in arson. There has to be a murderer in homicide. There has to be a thief for larceny. That doesn't mean there has to be injury as in, ow, he hurt me, or loss as in, he stole my wallet. It can be some other kind of harm, like the intent to harm, defraud, intimidate, or threaten any person. Speeding is a crime. And I know you don't want to think that it's an infraction. It's a crime. You're like, well, what's the corpus delicti? It's because people don't understand that corpus delicti just means that there has to be the thing that was like, the car went really fast would be the corpus delicti for criming, for speeding. The car was going in excess of the speed limit. But now in order to get a ticket for it, you have to be driving the car. There has to be a person that is driving the car, right? So if you shoot the car out of a cannon, nothing. If the car slips into gear on a hill where the speed limit is 25 and it rolls down the hill at 50 miles an hour, that's not the crime of speeding. The corpus delicti would be the car going faster than the speed limit and a person driving the car. These two together involving the commission of a crime by somebody, and thirdly, the accused family, etc. So, yeah, so I guess speeding is it's not a general intent crime. It is a, what do they call those? Why am I drawing a blank on that? Oh my God, like statutory rape. There's no mens rea requirement. I don't know why I'm drawing a blank on that. I'm having a brain fart. It's been a long day. Anyway. So, yeah, I guess speeding, you wouldn't have to prove a mens rea element. So, I guess, but like statutory rape, there has to be someone's criminality, as in being the source of it. But yeah, the general definition of corpus delicti, so it's a corpus delicti rule, and it prohibits the admission of an extrajudicial confession into evidence in a criminal case unless the prosecution introduces some evidence independent of the confession that the crime in the confession actually occurred. So what has happened in the past is people have pled guilty to murder, right? But they can't find a body. So do you charge them with murder? I mean, you've got a confession. That's good enough, right? So the corpus delicti rule requires some corroboration of the first two elements, an injury or loss and a criminal agent, although it does not also require any independent evidence that the defendant was the criminal culprit. So you have to have a body, or in murder, you'd have to have like a murdered body. And then if somebody admits to it, then that's good enough. The rule was not intended, however, to ensure that all confessions are corroborated in specific details or to ensure the suspect does not falsely confess to a crime. Now, if I remember this correctly, this was kissing the penis. Appellant denied the attempted aggravated assault charge against Julian, testified that though he rubbed his penis on Julian's behind, he did not have any intent for his penis to touch Julian's anus. Appellant denied the aggravated assault charge and testified that though he put Julian's penis on his mouth, he did not put Julian's penis in his mouth. When asked why he'd confessed in writing to putting Julian's penis in his mouth, appellant said he simply misread the confession before he signed it. The jury evidently rejected appellant's trial testimony and found him guilty on both counts. So this is going to the corpus delicti rule. There has to be evidence. So what they're going to look for is they're going to look for any evidence that Julian's penis entered his mouth or that his penis touched Julian's anus or something along those lines. Lovely case. Going to give me some sweet dreams tonight. Thank you very much for citing it. But I'll bet our good Mr. Freeman had no idea what he was citing when he put it in there. And I'm sure that there are some people in the apparently there are some people in the community who would probably enjoy reading that, and that's sad. Anyway, I'm discombobulated. All right, so there was Salazar. So it doesn't say what he's thinking it's saying, or I have no idea what he thinks it's saying. So in this case, the corpus delicti would be from the indictment. The corpus delicti, there was messages posted by you, Mr. Freeman, intentionally knowing using the name and persona of someone else to post the messages. That's the corpus delicti. The messages were posted that were intended to harm, intimidate, or threaten somebody from her name. Or from that person's name. I shouldn't use gender specific. Anyway. So that the corpus delicti is in there. You're simply misunderstanding what corpus delicti means. So, yeah. Even if this absurd claim is blah, blah, blah. All right. Even if the absurd claim is made, harm is not a necessary element of real crime. And again, harm can be the peace and dignity of the state. So there you go. And it's not an absurd claim. The complaint is still fatally flawed, as there is no accusation alleged defendant violated anyone's legal rights. You threatened, harassed, or something else. You intentionally, knowingly use the name and persona of this person to post one or more messages on or through an internet website, namely Facebook, with the intent to harm, intimidate, or threaten that person. So, harm, intimidate, or threaten. You intended to harm, intimidate, or threaten them. That is the... You threatened their legal right to be free from harm, intimidation, or threats. There you go. It is fundamental that an adversary proceeding requires true adversaries. Yes, it's you versus the state. The state thinks you're a criminal. You think you're not. There are not true adversaries because I am not confused of anything real or, and then for some reason in italics, imagined. You are accused of violating a very specific section, 33.0, was it 33.07 of the Texas Penal Code. Number 2, the complaint is unfit for adjudication. Because American courts are adversary systems, the complaint is unfit for adjudication. So he's citing Poe v. Ullman. Poe v. Ullman. it's for declaratory judgments that, so they were, in Connecticut, it was illegal to give contraceptive devices, but the state wasn't enforcing it. The principle was given early application, has been recurrently enforced that the court's refusal to entertain cases which disclose a want of a true adversary contest of a collusion of actively asserted and differing claims. Such cases may not be collusive in the derogatory sense of this, how in the sense of merely colorable disputes got up to secure an advantageous ruling from the court. The court has found unfit for adjudication any cause that is not in any real sense adversary, that does not assume the honest and actual antagonistic assertion of rights to be adjudicated, a safeguard essential to the integrity of the judicial process, and one which we have held to be indispensable to adjudication of constitutional questions by this court. So, the parties have an appeal from the legislature to the courts that the latter are given immediate and general supervision of the constitutionality of the acts of the former. Blah, blah, blah. So the problem in this was that the state wasn't enforcing the statutes. So if they're not enforcing the statutes, there's no reason to bring suit. So he asked that the Connecticut statutes prohibiting his giving of contraceptive devices to be adjudged unconstitutional. The state wasn't enforcing it. There was no true adversary. Does that make sense? In this case, though, with Mr. Freeman, the state is enforcing it. There is an adversary. And then he says, even if the phrase corpus delicti is not used, then there is no doubt this is not an adversary proceeding, as there are no allegations I violated any rights. Again, you violated a criminal statute. No corpus delicti. The corpus delicti is the body of the crime itself. Yes, it is. He goes on and on about corpus delicti. It's a sovereign citizen thing. They think that there actually has to be like, show me the body, show me the actual person who's injured, show me where they got hurt on their leg. That kind of bull crap. It never works. This is a stupid argument. It is frivolous. No court will entertain it. Virtually every American jurisdiction argues it's an absolutely essential element of any crime and is consistent with the stated purpose of the American governments. So then he cites People versus this is People v. Sapp. This is California. Absolutely no applicability to Texas. And this is the applicability of the corpus delicti rule to the financial gain special circumstances. This is in a murder case. He said that he took money for the job to kill the guy, so that would enhance the penalty. There was no evidence of it, or he agreed to kill him for the money. So there's no evidence of money. So they have to prove it. And so we held the statutory language stating that felony murder special circumstances must be proved pursuant to the general law. That made the corpus delicti rule requiring proof independent of the defendant's statements applicable to the felony offense underlying a felony murder special circumstance allegation. So, yeah. So again, this is just saying that you can't be prosecuted for a crime if the only evidence of that crime is your admitting to having committed the crime. That's it. And then, okay, so McVeigh v. State is the next one. And again, all of these are on Mark Stevens' Adventureland. So this is McVeigh v. State. This is a Supreme Court of Georgia case from 1949. Again, of little to no practical relevance to Texas. In defining corpus delicti, Wharton says it's made up of two elements. Blah. Again, so what's going on in here? Let's see what's going on. He was indicted for the murder. Indictment charging the defendant did stuff. Trial, the jury returned a verdict. The state's case rested upon the following evidence. Stringfellow testified he was the brother of Frank, and the last time he saw his brother alive was at the home of the witness, when his brother left in the company of one Dave Walden, that a suitcase exhibited to him was one belonging to his brother, which he had at the time he left, and previously, so there was just identified the skull, good health, witness saw him give a shot of narcotics on the day his brother left. I'm positive the skeleton I saw. So now we have the body. We have evidence of somebody being dead, but we don't know that he was murdered, and we don't know that. Let's see. He made an investigation and he went to where the body was buried. He identified the skeleton. So yeah, there's a body. Yeah, so that's what they're going on here. There was a body. So one element of the corpus delicti is as essential as the other. In the absence of extraneous evidence, all elements of the corpus delicti, the proof is sufficient to corroborate the confession. Applying the foregoing principles, was the verdict finding the guilty sustained? Since the confession alone will not suffice, it's necessary to determine whether the corpus delicti has been prima facie established by independent evidence. If so, then the confession might be considered by the jury in addition to the independent proof, etc. So again, it's the exact same rule. There's no difference. There was a body. See, there was an actual body in this case. So if you're thinking that corpus delicti means just the physical body of somebody, that's not what it is. It has to be, like in the case of murder, there has to be a corpse that was killed by murder. There has to be a murderer. And you've got to be able to put those two together. Well, okay, so technically it wouldn't be a corpse that's killed by murder. It'd be a corpse that is killed by some means that suggests foul play. A corpse that died because of something that suggests foul play. So you got to have the body. Then you have to have somebody who did the foul play. You need those two things. And in this case, again, we have the crime was again. So anyway, I'm not going to drag you through all of these. Yes, I did look them all up. There's Hawaii. This one, People via Cento. This one was Illinois. Ooh, it's termed the corpus delicti. Woo. Was this one that wasn't... There's several of these that weren't accurately quoted by Mark Stevens' Adventureland. And then this is another corpus delicti one. Ooh. He was convicted by the court sitting without jury of assault on a minor child. Sentenced to 1 year under jurisdiction, blah, blah, blah. He contends that they failed to prove the corpus delicti. Was called as a witness on behalf of the state. Compelled. She testified she'd been married to him. They've been living together with Tracy and other 3 children. Appellant returned home from work, and Tracy was playing with her other children. She left the children in her husband's care, so she go to the doctor. When she left home, Tracy's body was free of bruises, and when she returned, Tracy was standing up like she'd been crying, and had wet and she had vomit in the bed. That she did not examine Tracy that night, but the following day she noticed some fingernail marks on both Tracy's arms, which she treated with Vaseline. The following day, Tracy would not eat, and then when she went to hold her hands in order to feed her, she started crying like her hands were hurting her, and then she had bruises on her arms, etc., etc. So they're trying to bring it back to that day. And so again, it goes... There's circumstantial evidence. They're just trying to tie it back to the person on these. That's all they're doing with corpus delicti. All right. So since there's no proof that he was at home when Tracy was injured, so they know that Tracy was injured, but they have no proof that he was at home when she was injured. That's all he's saying. So they have to prove that. All right, and this one is Commonwealth, Massachusetts v. Ruddock. The evidence, student demonstrators, blah, blah, blah. Again, it doesn't really matter. It's the wrong state, and it's not proving what he thinks it needs to prove. State v. Hill, Supreme Court of New Jersey. Conviction of murder, arguing corpus delicti, blah, blah, blah. God, I can't believe that he actually... Commonwealth v. Maybe. This one was a misquote. I remember that. It's long been a fundamental... Yeah, let's look at Mark Stevens on this one. So this one is Maybe. Control F and M-A-Y-B-E-E. All right. It's long been fundamental to the criminal jurisprudence of this Commonwealth that a necessary predicate to any conviction if proof of the corpus delicti, the occurrence of any injury or loss, i.e. the occurrence of any injury or loss, the occurrence of an injury or loss. Yeah, this one was a misquote. Anyway, no big deal. Yes. Oh, what is this? It's gone. Gosh golly. Reload, you. Oh, they're not going to load now. He quoted Amjur second. It was a misquote. And that was a section, what was it? Yeah, 1476. Boom. 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 Evidence of corpus delicti generally. The corpus delicti rule requires the corpus delicti or the body or substance of the crime be proved independently from an accused extrajudicial confession or admissions. The corpus delicti of a crime consists of two elements. So he didn't quote, I don't think, the whole thing. Yeah, so he didn't quote the whole thing. He starts off with the corpus delicti of the crime consists. He doesn't quote the corpus delicti rule requires. But then he says down here, this is not the same as the corpus delicti rule, which is not an element of the alleged crime, but a procedural rule. He's retarded. He doesn't understand what he's reading. He's just, I don't know what he's doing. All right, and then US v. Shunk. Are you US v. Shunk? Where's US v. Shunk? Oh, US v. Shunk was way back. No, where's US v. Shunk? Where's US v. Shunk? There we go. US v. Shunk is an appellate case from the 10th Circuit. Nothing to do with Texas. And it's also about corpus delicti. Again, lack of jurisdiction. All right. Moving on. Lack of jurisdiction. Because there is no corpus delicti, there is no crime. Yes, there is a corpus delicti. Yes, there is a crime. Yes, there is a so-called crime, he says, alleged on paper, but the allegation fails to meet every legal standard of what a crime or case is. No, it doesn't. Also, because American governments are established for the sole, he says, sole purpose of protecting rights. No, that is not true. A true crime or case requires a violation of a legal right. This does involve you threatening or harming or, what was it, intimidating somebody. Let's look at the indictment again. Harm, intimidate, or threaten. Yep. People have rights not to be harmed, threatened, or intimidated. Defendant, not alleged defendant, is not accused of violating anyone's legal rights. You're violating the legal rights of the state, and you're violating the legal rights of the person whose name I redacted. Therefore, there's no crime, case, or cause of action pled, and the court has no jurisdiction. Again, you haven't proven that at all. All your crap about corpus delicti was just pissing in the wind. All you're doing is pissing on yourself doing that. And then he cites National Organization for Women v. Schindler, which should be this one. And this one is, again, a civil case. So nothing to do with what he thinks it does. And so the threshold questions is whether they have standing to bring their case. Standing represents a jurisdictional requirement, which remains open to review at all stages. Basically, courts can never waive standing or jurisdiction, subject matter jurisdiction. But in this case, the courts, as we've already looked at the Texas Constitution, which was here, the court, Texas court, has jurisdiction over all actions, proceedings, and remedies in Texas, unless somebody else is assigned it. And the Texas Penal Code 1.04 says the state has jurisdiction over an offense that a person commits by his own conduct or the conduct of another for which he is criminally responsible if either the conduct or the result is an element or a result that is an element of the offense occurs inside the state. If the conduct outside the state constitutes an attempt to commit an offense inside the state, etc., etc., etc. So yeah, if either the conduct or a result that is an element of the conduct occurs in the state, then the state has territorial jurisdiction, and the court has subject matter jurisdiction, and you got nothing. Because American courts are adversary systems, the complaint is unfit for adjudication. This is again Poe v. Ullman. This was... Is this Poe v. Ullman? I believe this is Poe v. Ullman. No. Which one's Poe v. Ullman? James v. State. Come on. Poe v. Ullman. There we go. There's Poe v. Ullman. Oh, yeah. I'm sorry. I was right there. Tired. This is the exact same thing he's quoting again. The Supreme Court has found unfit for adjudication in any cause that is not in real sense adversary, blah, blah, blah. And again, this is an adversary proceeding because the state is initiating a criminal action against you. There are allegations and there are supporting facts. The supporting facts were apparently shown to get the grand jury indictment. All right. And it's not plaintiff. It's not the plaintiff. The alleged person who was harmed is a citizen or is somebody. I don't know if she's a citizen of the state of Texas. I don't even really care. But he did it in the state of Texas. So the state of Texas laws are applicable. The person who he allegedly threatened or intimidated or harassed, I don't know where that person is located. Could be anywhere. But it's still a crime in Texas. It doesn't matter where the victim is. It matters where you are. We just looked at territorial jurisdiction. All right. So then he says, no evidence of presence within the state and laws applicable. Obviously there are, but okay. There are no facts pled. And again, you don't plead. There aren't pleadings. Pleading, like, so when you're filing a complaint or an answer in a civil case, those are the pleadings. A criminal case has an indictment. So there are no pleadings. The indictment said that he violated it. It's been proven to a grand jury. It's so ridiculous. I'm sorry. I know I keep going over the same things, but he goes over the same things, so it's kind of hard. I did skip a lot. You're welcome. Such evidence is essential to prove jurisdiction. No, it's not. He thinks they have to prove jurisdiction, but they don't. It's apparent that they have jurisdiction. The court is empowered to hear the case per the Texas Constitution. The state has territorial jurisdiction over it. What else do you need? They have an indictment with your name on it. That's personal jurisdiction. You done, son. You're pleading the wrong things. You should have kept that lawyer because this is just steering you down the wrong road. I mean, I'm pretty new to being a lawyer, and this is just stupid on its face. Mere geographic location is not evidence of presence within the alleged plaintiff state of Texas. Yes, it is. If you're in, let's say, Dallas County's in Texas, you're in Texas. It's impossible to prove my presence within the alleged plaintiff beyond a reasonable doubt or preponderance of the evidence. I don't know what that's so weird. The state of Texas, while obviously not geographic, is at best political, as it did not exist prior to 1863. It is geographic, and it is political. Amazing. The phrase state of Texas appears to be not much more than a DBA or pseudonym for lawyers and police officers. He's a sovereign citizen. The state of Texas is an entity. It is a legal entity, and it has sovereignty over the territorial jurisdiction of Texas, except where federal law precludes it. As the laws of the state only apply within the state, there is no evidence and nothing alleged the law of the state apply to me. You were alleged to be in Texas. Texas has territorial jurisdiction. I don't know what to tell you, dude. That's alleging that the laws of the state apply to you. And the thing with statutes, again, the court takes judicial notice of the statute. No one has to prove the statute is valid. If you want the statute to be not valid, you would have to prove that it's somehow unconstitutional by the Texas Constitution or by the U.S. Constitution. The burden would be on you to show that it's not a valid law. Then he says, if this is a criminal proceeding, it is, then the assigned judge is obligated to presume my innocence until it's proven beyond a reasonable doubt. Yeah. Sorta. Sure. Yeah. The judge may not assume the law is applicable now. Yes. The judge has to assume the law is applicable now, because it is an essential element of the alleged crime. No, the elements of the crime are stated by the law, but the elements of the crime, if we look at them, it's jurisdiction. Here we go. So it's got to be a person. It's got to be in the state of Texas. All right. Start. So you committed an offense if the person. So you have to use the name and persona of another person without obtaining their consent, and with intent to harm, defraud, intimidate, or threaten. And then you have to use the name that you're using to post or send one or more messages on or through a commercial social networking site or other internet website other than on or through an electronic mail program or message board program. I could diagram that out for you, but I think you get it. The essential elements are stated by the statute. The essential elements are not the statute. They're stated by the statute. Last, the argument the laws apply to me just because I'm physically in Texas has no factual support, other than the armed men with guns and pepper spray and batons and handcuffs who will make sure that they physically apply to you. All the court has at this point is an allegation I violated the laws of the state. Yes. That allegation is not evidence the laws apply. No, the laws are assumed to apply because the state says so and you're in the state. just because you're in the state. At best, all the prosecution may do is offer more argument and opinion. No facts proving the laws of the state apply to me just because I'm physically in Texas. Again, you don't understand. The statutes are presumed that nothing has to be proven on the statute. The statute could simply be stated. You violated the statute. These are the elements of the statute that you violated. This is what you did to violate the statute. The statute is just assumed. It is true. It is there. It is, unless you show that it violates the Constitution of Texas or the United States, or there's some other law superseding it in some way, then you're done. They don't have to prove that the law applies to you. The law applies to you. No proof required. Court's jurisdiction is not enlarged by police authority or custom. Nobody ever says that. The court's jurisdiction is stated in the Constitution of Texas. The jurisdiction of the courts is limited to protecting rights. That is not what the Constitution of Texas says, so you are wrong. This can't be enlarged by alleging the police have authority to issue tickets. I have no idea what you're talking about there. That is retarded. You should feel bad for making that statement. This has nothing to do with tickets. Such authority does not work to trump fundamental limitations on the courts. Again, the jurisdiction of the court is laid out in the Constitution of Texas. No amount of police authority may enlarge the limits of the adversary system. Adversary systems require true adversaries. This requires allegations and proof of injury. The plaintiff has failed to make such allegations. They obviously have not failed, and it's not a plaintiff. While police have authority to issue traffic tickets, they must still allege injury. Again, why is he talking about traffic tickets? What do traffic tickets have to do with this? For fuck's sake, bro. I wonder if he copy-pasted this. While police may have authority to issue traffic tickets. So we're looking for, let's see. No, he didn't get it from there. Let's see where he got it from. Wait, they do something weird. Well, police have authority to issue traffic tickets. I don't know where he got that from. So he must have come up with that on his own? They still must allege injury. Let's see what we got here. They still must allege injury. This one was broken. Account suspended, but it looks like it's interesting. Ah, it's another Mark Stevens one. Oh, good God. So it is another Mark Stevens deal. Okay. So he's just copy-pasting out of Mark Stevens. I'm sure the judge really appreciates that. All right. Okay, they still must allege injury for the court to acquire jurisdiction. And again, all they have to do is allege. All they have to do is just cite the statute. It is assumed that any violation of any statute is against the peace and dignity of the state. All right. Conclusion. Because the plaintiff has failed to allege the required elements of a cause of action / crime, and there's no corpus delicti. The court has no jurisdiction. As such, the court should either strike the complaint filed against the alleged defendant, or dismiss it. And so he submitted this the 21st day of May 2018, which is fun. So May 21st, he hands this in. I hope I still have somebody watching at this point. May 23rd, order of recusal. Be advised of the pleadings. So recusal is when the judge is like, I've got like, I can't hear this because like I'm biased, or, you know, I've got a dog in the fight in some way, or I have knowledge of the goings on that are, I already have knowledge of like of the crime and the events and circumstances and things like that aren't what has been brought forth by the prosecution, or something along those lines, right? So, being advised of the pleadings, parties, issues, and subject matter of the above case, and I'm sure it's the pleadings that are really doing it, the undersigned voluntarily recuses from hearing any further matters in this case, and requests the presiding judge of the First Administrative Judicial Region assign a judge to the case. This is on the 3rd. I don't know what time this was signed, but this judge wants nothing to do. What was the name of the judge? Let's see what the name of the judge was. She was on, was it on here? Amber Givens Davis. She's like, nope. Damn you. She noped the F out of there, boy. She saw a soft citizen coming, and she's like, nope, nope, nope. So that was this one, Amber Givens Davis or something like that. And then this guy was like, based on a recusal, this order was transferred to the 363rd District Court of Texas, and that's Ray Wheelis. So it never got sent to the Criminal District Court 5. So that was probably why Criminal District Court 5 didn't know anything about it. So there you go. They did give him this in Criminal District Court 5, but apparently he's been transferred. If you look online, he's been transferred to the 363rd District. So his reset date is an announcement hearing, 6/6/18. Not sure what they're doing on announcement hearings. Is it another arraignment? I don't know. I don't know. Maybe they can't call it an arraignment because there was an earlier one or something. I don't know. And then this is the docket. He's transferred to 363rd. And there you go. There's my trip through Camp Happy Land. I hope you enjoyed it. Boy, that's some. There's our boy James. I thought he was like just dabbling his toes in sovereign citizenry, but he's full on Sov Cit, and it'll be interesting to see the way this shakes out. He's really not doing himself any favors. I know there are people who are going to think that that what he said made sense, but it's sovereign citizens. It doesn't work. It literally doesn't work. If you ever get a chance, law libraries are free. Pick your favorite sovereign citizen who will tell you about all the cases they've won. Figure out what state they're in, so that way you can figure out their federal district court, like what circuit they're on and what state they're in, and look up any cases in their state that have their name on them in federal or state court, and look to see if they've won. And then if they do win, look to see if they win because of what they've done, or because, like this was Paul Bickle. Somebody pointed him out to me. He just won a case. He had 11 losses and he just won a case. And he won a case because the prosecution just screwed the pooch just entirely on his. He was driving without a license and driving without insurance, and the prosecution just screwed the pooch entirely. And it wasn't him that did it. The judge recognized it and dismissed the case. So it's just sovereign citizens lose. They just lose. Please avoid them, or please avoid using them. There's a reason why people pay for lawyers. We are expensive, but your odds of winning drop dramatically once you start filing motions like this. Good God. Once you start filing motions like this, you're done. If you're resting your case on corpus delicti, you've already lost. Terrible. Anyway, thanks for watching. Have a great day.